Mr. Brooks, you're talking about an irrelevant matter. I'm starting the trial.
Of course, right here that says it's a civil matter.
Mr. Brooks has nothing to do with this case.
My trust is being sued?
I have no idea what you're talking about. So
I got the paperwork right here.
all right, I'm going to excuse the jury right now, given this disruption. I'll rise for the jury.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.
I'm not gonna, this is...
You are not being respectful to this proceeding or to this jury. No, it's not. With all due respect, stating that doesn't make it respectful.
I was given this paperwork by you.
Mr. Brooks.
Monica Paz.
Stop talking till the jury is out.
Okay,
thank you.
So why couldn't we address this before they came out?
I'm not going to address it.
That
Bottom
was the time
line.
to address it, though. We're supposed to do all the addressings before the jury comes out, before we start the matter.
Please be seated.
I was trying to simply address paperwork that was given to me by you, Your Honor. That states
Mr. Brooks.
It states that
you have interrupted me
matter.
Repeatedly. You are on the verge of being removed to that courtroom. I don't want to do that. I want you to stay here. But you keep interrupting me and bringing up irrelevant matters. I told you yesterday, as a courtesy that was provided to you, so that you would frankly not complain that you didn't get it as quickly as possible. Okay? I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of court. But from now on, I am not going to be the messenger and give you documents that you request to the custodian of the records or from the custodian of the records. They will simply have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up. All right? It is irrelevant.
It needed to be noted for the record.
It doesn't need to be noted, sir. All right? The jury's coming back out, and I'm going to warn you, if you bring this up again, I will pause, and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to that.
Did you hear what I said, sir?
No, I did not. I object to that, Your Honor.
Well, you can object, and your objection is noted, but if you interrupt when this jury comes out, they will go, I will have them taken out again, and you will be removed to the next courtroom.
You can't, what is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the other cases that I've cited previously. I'll make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt. Yesterday, sit down. Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 50 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't verified by proof any of what I said.
And none of that is required, sir.
Because it is. You can't verify.
Your belief that that's the law doesn't make it so, Mr. Brooks. Your belief that these are legitimate legal positions doesn't change the law and doesn't make it so.